Good afternoon and welcome. It's great to see so many here today for our discussion on data privacy. We're honored to have esteemed leaders from the Department of Justice and the Federal Trade Commission. Our program will proceed in three parts. We will hear remarks from Peter Winn from the Department of Justice, followed by a conversation and questions. We'll do the same with Commissioner Wilson. Then we'll move to our panel. Just as a reminder, AEI takes no policy positions. And let me just make a quick thank you to the many AEI staff people who worked so hard to make today's event possible. We truly appreciate it. Now, it's not an accident that the U.S. has led the commercialization of the Internet. We can trace the policy underpinnings of this to our Constitution and its frameworks for interstate commerce. Our founders, Madison and Hamilton, envisioned a single market for our nation from the very beginning. They recognized the importance of all Americans enjoying the same rights and freedoms, and they wanted to avoid the patchwork of economic regulation generated by self-interested states, which would reduce enterprise for Americans overall. If we fast forward to today, we can see the wisdom of that approach. Enterprise generated by America's information and communications technologies drive 10% of our GDP and comprise 1/3 of the world's total. It's no accident that our policy choice to allow permissionless innovation led to this development. Notably, we adopted a trust-based model, which doesn't assume that the collection of data itself is harmful, but rather directs law enforcement to deceptive practices and evidenced harms. However, adopting tighter controls for sensitive information, as we've done for information from children and in financial and health areas. Now, this model is not perfect, but it's produced tremendous benefits for consumers and innovators. Now, however, it's under threat by controls imposed by the European Union, as well as California, which have adopted onerous rules dictating how firms are to manage information. Beginning in 2020, firms operating in California will have to adhere to 77 specific requirements. In order to do this, they have to spend a minimum of $100,000, if not $1 million. We can also look at what's happened in the European Union after the first year of its general data protection regulation. More than 1,000 U.S. newspapers no longer are available in the EU. Dozens of innovative ad tech firms have closed their doors, and the net effect has increased the market share of the largest internet platforms, those companies who have the money and resources to comply with heavy-handed regulation. The specter of similar effect from California's rules has prompted Congress to take up the issue. This has been an important opportunity to review what's working in the U.S., what can be improved, and how best to ensure privacy protections for Americans without destroying the freedom of speech or enterprise. Here to discuss these frameworks today is Peter Winn of the the Director of the Office of Privacy and Civil Liberties and the Acting Chief Privacy and Civil Liberties Officer of the Department of Justice. This office ensures that the DOJ operates with fidelity to America's laws, regulations, and policies, and ensures that any new policies will maintain these rights and freedoms. Prior to his time at DOJ, Peter served in the U.S. attorney functions in Texas, Washington State, and with the Privacy and Civil Liberties Oversight Board. You will find that Peter thinks deeply and thoughtfully about these issues, as exemplified by his many academic articles on these topics, his teaching at the University of Washington and Southern Methodist University, and his advanced degrees in law and philosophy from Harvard and the University of London. Please join me in welcoming Peter Winn.
Thank you, Roslyn, for a generous introduction, and thank you, everyone, for coming and being part of this discussion. It's an honor to speak at the American Enterprise Institute. You may not think the Department of Justice has much in common with the American Enterprise Institute or American Enterprise, but we are both in the business of delivering value, creating value. Businesses, of course, create goods and services that their customers value and brands that are trusted. The Department of Justice is here to enforce the law, defend the interests of the United States according to the law, and ensure fair and impartial administration of justice. And that's the value that we create, and our brand has to be trusted. Today, both government and business face a tsunami of change from the revolution in information technology. It has allowed businesses to harness knowledge more effectively to compete in the global economy, and it has allowed the federal government to step up its use of information technology to more efficiently and effectively meet the needs of the American people. For the Department of Justice, this includes combating global terrorism and crime, but information technology is a double-edged sword. It also creates global competitors for business, and it brings new and unexpected threats from our global adversaries. I recently read a book called Measure What Matters. It's a book by the venture capitalist John Doerr, who argues we can't win by making better widgets. We will only win if we create better, we make better decisions. To make better decisions, we need better information. Today, much of the information we need concerns people. Knowledge about people is what businesses use when they create economic value for their customers, and what law enforcement agents use to investigate crimes and create the value of public safety. In order to fulfill its mission to ensure fair and impartial administration of justice for all Americans, the Department of Justice needs to handle a lot of information about people. It does so within a legal framework that governs what we are permitted to do with personal information and what we are not permitted to do. We are careful when we handle this kind of information because the American people, if they lose confidence in our ability to handle sensitive information lawfully and appropriately, this could mean losing the authority to access the information we need to do our jobs to carry out our mission. I believe the trust is also mission critical for the private sector. So long as American consumers trust a business to handle their personal information appropriately, then that business should be able to get the information it needs to create value for the American public. There's now a public debate going on about whether we in the United States should change our laws governing how personal information is handled by the private sector. In this debate, it is important to keep in mind that government agencies are also important users of consumer information. This information enables them to fulfill their missions for the American people. Any comprehensive federal privacy law must recognize and preserve the government's lawful access to data for law enforcement, national security, and other appropriate public regulatory purposes. Investigative tools used to obtain commercial data and other information from businesses in the United States for criminal law enforcement or public interest purposes are already strictly limited by law in DOJ policy. For instance, in domestic criminal investigations, the Fourth Amendment generally requires law enforcement officers to obtain a court-issued warrant before conducting a search, and when warrant requirements do not apply, government searches are still subject to a reasonableness test, ensuring the U.S. government does not have limitless or arbitrary power to seize private information. Numerous other laws govern how we collect and use personal information in connection with investigations, and where the law gives us discretion, we have developed established policies and procedures to ensure that legitimate privacy interests are protected. I believe federal comprehensive privacy laws should implement reasonable privacy standards that take into consideration not just reasonable consumer privacy preferences, but other legitimate uses of information. Privacy is not about giving individuals complete control over personal information about them in all contexts. Some argue that the United States needs a privacy law like the one in the EU, based on a framework of universal rules that apply irrespective of context, with serious penalties for noncompliance. I disagree. Frameworks like the GDPR, based on universal rules, often have consequences that go far beyond their intended purposes and can end up negatively impacting core public safety missions. For example, since the 1980s, when a person registered an internet domain name, certain limited contact information was made public. A nonprofit entity, the Internet Corporation for Assigned Names and Numbers, or ICANN, managed this information and made it publicly accessible in its online database called Whois. As the department's Cyber Digital Task Force made clear last summer, access to the Whois database is critical for the department's online data review and reconnaissance efforts when detecting, deterring, and disrupting cyber threats. Despite the Whois database's obvious role in maintaining public safety and accountability around the world, the Dutch Data Protection Authority in 2017 declared that the database was in direct violation of the GDPR. As a result, a large number of law enforcement agencies spent significant time and resources trying to remediate the collateral negative impact the GDPR had on law enforcement's legitimate access to Whois information. This is only one of many negative consequences that were not adequately addressed before the GDPR framework was implemented. One advantage of the U.S. risk-based or sectoral privacy system we have is that it limits much of this kind of collateral damage caused by one-size-fits-all approaches to privacy. In the United States sectoral system, we have different privacy standards for different areas of social and economic interaction because there are differences in how individuals may be impacted by the mishandling of their personal information. The risks of harm to individuals is different depending on the nature of the social or economic interactions for which the information is used. The United States risk-based approach focuses on the actual risks of harm because that is what matters. This is also the way to preserve public trust in government and private sector institutions so they can continue to access the information they need about individual people so they can function effectively and continue their mission of delivering value. In general, American privacy laws attempt to balance the level of protection needed to keep the public's trust with the need to ensure that government or private sector enterprises can get the information they need to function. To someone outside the United States trying to figure out how all this works, American information privacy law, may look to them like a Rube Goldberg machine. But its structure reflects the actual risks to individuals, and stronger controls are put in place when the risks to individuals are greater, while limiting the unexpected collateral effects of the legislation. In contrast, a universalist approach to privacy without regard to context, which is characteristic of the EU system, where they emphasize individual control of information about themselves, that tends to discount the importance of the personal information that both government and private sector enterprises need to carry out their missions successfully. And they tend to result in collateral impacts to legitimate uses of personal information. Understanding the democratic process in the United States is also important to understand how U.S. privacy laws work. By the time legislative processes have ended in the United States, whether at the federal or the state level, all the major stakeholders have weighed in, and there usually needs to be a substantial consensus among them, or at least a clear understanding of the risks and why the privacy standards are needed before a bill can become law. Some bemoan the fact that the American democracy, the American democratic process, requires greater buy-in from the people who will actually have to comply with the laws that we enact. But a requirement of more buy-in for a proposed law up front results in greater compliance when it becomes law. Robust democracy has a lot to do with compliance, and compliance has a lot to do with trust. This is something people need to keep in mind when they compare the U.S. approach to other countries' approaches to privacy. Do the laws as implemented maintain the trust of the people that their government and their private sector are actually handling their personal information appropriately as they carry out their respective missions? This question is not about law on the books. It is a question about law in action. An example of law in action. Let's look at compliance with the Privacy Act. This is a law that has helped maintain trust in government for more than 45 years. Privacy Act was passed in response to a terrible loss of trust in government that took place after the politically motivated surveillance and investigation of individuals that came to light during the Watergate era. One of my responsibilities at the Department of Justice is to make sure that our agency complies with applicable U.S. privacy laws and policies, that we are actually doing what we are supposed to do. The Privacy Act was also one of the first laws in the world designed to protect against the risks presented by computerized information systems. It did this by implementing what many refer to as the Fair Information Practice Principles, or FIPS for short. The FIPS embody such ideas as notice, transparency, reasonable limitations on secondary use of information, individual access to identify, correct errors, data security, and accountability. As implemented in the Privacy Act, the FIPS recognize the mutual interest of individuals and government agencies in the accuracy and reliability of the information the agencies use to make decisions. And they enlist individuals in a partnership with the agencies to achieve that goal. While not perfect, the success of the Privacy Act in maintaining trust stems in large part from the fact that the framers of the Privacy Act explicitly rejected the model of privacy as a right of individual control. Instead, the Act was designed to sustain public trust in government information systems, and under this framework, both the individual and the agency share a mutual interest in maintaining the accuracy and reliability of the information the agency needs to function. The Act gives people the tools they need to work together to build trust. But I can tell you from my personal experience at the Department of Justice that keeping the department systems in compliance with the requirements of our privacy laws, well, it's a continuous challenge. Privacy in action is ultimately about resources, money, and people. When I compare the challenges that I face trying to make sure that our agency complies with the many information privacy laws that we're subject to, and I compare that process, the challenges that we're working with on every day, with the struggle that my counterparts in Europe at data protection authorities face to get compliance with their vastly greater obligations, literally millions of systems, I cannot even imagine what it will cost in resources for them to achieve anything close to full compliance. And yet, the budgets of many national data protection offices under the GDPR to oversee the compliance of all public and private sector institutions in whole countries are smaller than my budget at the Department of Justice to oversee compliance with just over 100,000 people and 42 components. As the genie in Aladdin says, these European data protection officials have phenomenal cosmic power, itty-bitty living space. The bottom line is that American business and government needs access to personal information to carry out our public and private sector missions successfully. And to do this, we need the trust of the American people. We can only earn this trust by making sure we handle their information appropriately and lawfully. I therefore invite you to work with Congress to safeguard our democracy by building privacy frameworks with the participation of all stakeholders. We should avoid characterizing privacy as an adversarial framework based on ideas of control, and instead think about privacy as the creation of structures that promote trust. To accomplish this, we should preserve the American risk-based approach to information privacy law. This approach focuses on making sure government and businesses handle the personal information of Americans appropriately, safely, and securely, and we need to focus on what it will cost to achieve high levels of compliance. For compliance is the only reliable way to promote sustainable public trust. Thank you. Thank you.
So thank you, Peter, for excellent remarks. I think that it demonstrates, perhaps for people who haven't thought about it before, there isn't just one model for how we do this. And we're in an interesting time right now where we've had European rules on the books almost for a year. And because of our internet world, we are studying models in many countries. And it's perhaps highlights that we may have taken for granted some of the benefits of the U.S. system, and now we have the chance to review them. You've thought a lot about these issues for your whole life, and what I think one of the areas where you've really highlighted an important model to think about a trust-based system is in the work of Nobel economist Elinor Ostrom. And I know our other panelists will touch on this, but just to sort of table set, it's interesting because she actually studied how stakeholders manage shared resources, a fishery, commons of some kind. And what she described, there were property rights, but not necessarily private ownership. And there wasn't even a government entity there. And how did the stakeholders come together to share and manage the resource? So I think that this is maybe, in many respects, how we've kind of managed the internet in many regards. Now, I know from law enforcement perspective, you have to go exactly by what is written, but there might be something that you could share from that perspective.
I'm glad you asked that question. Elinor Ostrom's one of my great heroes. It's funny that the people who I find to be most helpful in my thinking about privacy tend to be women. When I think about Ostrom, I always think about what I tell my students when I teach privacy the first day. I say, remember when you were kids on a playground and you're 4 or 5 years old, kindergarten, first grade, and you're out on the playground during recess. That's a state of nature, good or bad, depending on where you are. But little Annie turns to her friend, or supposed friend, Sally, and says she thinks Timmy's cute. And, of course, radio-free Sally, we know where she's going. Annie loves Timmy, broadcast. The teacher doesn't intervene. Annie, of course, is humiliated. Timmy's embarrassed. But so long as Timmy and Annie don't use self-help and hit Sally, the teacher leaves the kids alone. And the kids have developed, and we all know this, a self-regulating ecosystem. It's called the blabbermouth system. Okay? And it works pretty well. I mean, I'm not saying that Sally always gets punished appropriately. Sometimes she's over-punished and completely shunned, and sometimes she's under-punished and gets all the attention. But the key about the blabbermouth system is the kids own it. And when kids own a system, suddenly it's important to them to be trusted. And the values get internalized, and they're self-enforced. And Elinor Ostrom studied these systems where the stakeholders keep each other honest. And they develop their own system of graduated punishments. And it's really important that the teacher does not intervene, because as soon as the teacher starts micromanaging the kids, the value of that self-regulating ecosystem gets destroyed because the kids will game the teacher. And Ostrom was just a genius. People tend to go into the privacy debate by thinking it's either got to be a Leviathan state, with some command and control system, like they do in Europe, or it has to be some sort of a property-based idea where individuals own stuff, right? And Ostrom, we all have heard about the tragedy of the commons, where we hear this story that if you don't have a property right or if you don't have a command and control system, the commons will be overused, right? Well, she went out and studied common pool resources, as you said, forests, irrigation systems, fishing waters, and she discovered that there weren't property rights and there weren't command and control systems. There were blabbermouth systems. And she recognized that these are a form of governance that can really provide meaningful trust. And when I arrived at the Department of Justice in this job, I got really interested in something called the AG guidelines. The FBI now call it it's called the DIOG, a terrible name, Domestic Investigations Operations Guide. I would strongly encourage you to look at those things, because putting those things together take all the stakeholders, they take months and sometimes years, and they maintain trust without lawsuits. Because when you go to an FBI agent and you ask them why, what's the source of pride? What makes an FBI agent an FBI agent? They're going to point to the DIOG. And they are constantly updating it. And we've seen those same kinds of structures in voluntary consensus standards, which businesses have come up with their own blabbermouth systems, their own FBI AG guidelines. And the privacy debate, because we've been looking at sort of either market-based approaches or command and control approaches, have forgotten that human beings are pretty good at putting together self-regulatory structures. And what's different about the self-regulatory structures is they internalize values, so they self-enforce. Because at some level, that's really the basis of trust.
Well, that's an excellent explanation. So I'm going to turn it over to the audience to see if we have any questions. And I would ask you, if you were going to make a question, please state your name and your organization, and make your statement in the form of a question. I see one over there.
Joel Thayer with the App Association, and I really appreciate the conversation. It's very interesting, especially I love the children analogy, so I might even use that. But I was interested in getting your thoughts on sort of how Europe has designed the GDPR and its relation to AI capabilities, because it seems to me that we have this overregulated structure. Certain things like artificial intelligence or even machine learning capabilities get hampered. So if you had any thoughts on that, I'd be really appreciative.
I'm glad you asked that question. I gave a talk with the former data protection commissioner in Germany named Peter Schar a couple of years ago now. And we had a similar conversation. And I was pleased to see that he also was the first one to say that if you look at the law in action as opposed to the law in the books, it's a scandal because, in his words, we in Europe are just as much of a patchwork as the United States. I would argue that that's because they're doing risk-based management as well. He would say, no, we have to give more resources and make sure we manage those. But one of the things he's actually said publicly is that he actually believes that artificial intelligence and big data is per se illegal under the GDPR. Now, not a lot of European data privacy commissioners will say that publicly, but a lot of them say it privately. And the whole point of this sort of the way they're using the FIPS, which we invented, by the way, but there's I would argue they've turned it into a command and control thing instead of a blabbermouth system, is that you get yourself in these jams. I mean, the FIPS were not really, I mean, if you're thinking about control and you put the model of individual control on the FIPS, which the founders of the FIPS rejected, you end up thinking, well, how can you specify the purpose when the whole point of artificial intelligence is to help you learn stuff you didn't know? You know, that you see the patterns kick out. We don't know the cause. And that's part of the magic of it, is that it provokes thought when it interacts with humans. But if you lock that down, you know, you're going to create yourself an innovation desert. So this is why I'm, forgive me if I'm just a, you know, broken record on the issue of trust, not control. And we need to look back on the original FIPS. They were designed to build trust. They were not designed. And in fact, in the HEW report, the founders explicitly reject, which is part of the legislative history of the Privacy Act, they explicitly reject privacy as a right of control. And they talk about mutuality and trust. What they did is they looked at what people were already doing with systems and how those systems, what worked and what didn't work, and then they came up with this model. We need to start doing more evidence-based empirical work to find out what works and what doesn't work. And stay away from Platonic universes where this kind of, it sounds great in theory, it looks great on the books, but it's really about law and action. And law and action is about humans, and it's about what actually builds trust and what doesn't build trust.
So I wish we had more time, Peter, but what I will just wrap up here with is one of the things Ostrom observed is, she said, well, maybe we can take the knowledge from the real world and it can inform the theory.
That's a great line. It's like any system that can work in fact can work in theory. Right. I mean, it's a joke, but it's a law that's called Ostrom's law.
Yeah. So, but it's wonderful to have you, and I knew that we wouldn't have enough time to cover all the issues, and we want to make sure that we can get the rest of our panel today. But I hope that all of you will take the time to review some of the resources we've discussed today. Also, if you're going to go to aei.org, you can see many of the interesting articles our scholars have written in light of this discussion of online data protection, and so certainly to further your thoughts on this issue.
Thank you.
So, thank you, Peter.
Thank you very much. Yes, I do. Thank you. I can, not a problem. I can sit somewhere else if you like. Okay, thank you.
It's my pleasure to... Sorry, you're switching mics. It's my pleasure to introduce Federal Trade Commissioner Christine Wilson, who was recently sworn in September 26, 2018, but she is in no way a stranger to the Federal Trade Commission. She was also Chief of Staff to Chairman Tim Muris during the George W. Bush administration, and she also clerked at the Bureau of Competition while attending Georgetown University. She's also spent a lot of time in this area of competition law in both law firms and as an in-house counsel. So we're very lucky to have her expertise at the FTC now, and we look forward to hearing from her.
Thank you, Shane, and thank you, Roslyn, for inviting me to be here today. It is a great privilege and a great honor. And before I start, let me give the standard disclaimer: the views that I express are my own and not those of any other commissioner or the staff at the FTC or the Federal Trade Commission itself. So Shane mentioned that I am an FTC recidivist. This is my third time at the FTC. And when I think back on the work that I did with Chairman Muris, it's very much that there are some parallels to what we're experiencing today. As Tim was going through his confirmation hearing, and then as he was getting settled in at the FTC, there was a lot of attention that was being paid to privacy and data security issues. And so at the very beginning of his chairmanship, we had dozens and dozens of meetings and spent hundreds and hundreds of hours talking to folks in trade associations, in industry, to legislators about the issues of privacy and data security and how to modernize in light of evolving technology. And one of the capstones of that effort was the do not call list. And Tim would tell you if he were here that that's his 15 minutes of fame. And obviously technology has evolved since then, and we're looking for new answers to new problems. But I will tell you, my favorite memorabilia from Tim's period as chairman is 2 Dave Barry articles that are autographed, and they're about the Do Not Call registry. And I don't know if you're familiar with Dave Barry. I actually grew up in South Florida reading Dave Barry before he was syndicated. So I have a little bit of Floridian pride in Dave Barry. But seeing those Dave Barry articles autographed and hanging on Tim's office forevermore always reminds me of the effort that we put into these issues and some of the very real strides that we made. We also brought some of the earliest cases in this area, including Eli Lilly and Microsoft. But obviously, time has moved on. The FTC has continued to do some really fantastic work in this area. I'm sure all of you know there is significant enforcement that's happened in both privacy and data security. We've brought dozens and dozens of cases. We've actively engaged in policy initiatives that are consistent with the agency's comparative advantage as an R&D institution. I think one of the things that makes the FTC really great is that it does have this deep history sort of embedded in its DNA of doing R&D, of listening to different stakeholders, of thinking about policy issues before we move to, as Peter said, law in action, because we want to be sure that what we're doing is very sensible and workable in the real world. And so we hold workshops and roundtables. We're actually doing a series of hearings now on competition and consumer protection in the 21st century. Some of you here are actually testifying at those hearings, and we greatly appreciate all of the input that we're receiving, both in the form of panelists who are giving of their time and their wisdom, and also more than 700 comments have been filed on a variety of topics, including big data, AI, privacy, security, and a wealth of other issues. And I think the upshot is that we are at an inflection point very similar to the one that Tim faced when he took office. I think there are a number of trends that are occurring that are putting pressure on us to think very differently and more comprehensively about the way that we address these issues. So today I'd like to touch on just a couple of areas briefly and then save time for Q&A. First, I want to talk about 3 of the trends I see that have led me to believe that we do need federal privacy legislation. I'd love to see it done in conjunction with data security legislation. I think those are largely 2 sides of the same coin. And then I'd also like to talk about what I would like to see in a federal privacy law. So first, let me talk just briefly about 3 trends that I see that I think are pressing us toward federal privacy legislation. And frankly, I'm not sure I would have given you the same conclusion even 2 or 3 years ago. First, implementation of GDPR and the passage of CCPA. I think businesses need predictability and certainty, and the patchwork that is emerging, I think, is going to be unworkable. It may work to have 50 different breach notification laws. You can tailor your operations to the lowest common denominator or the highest common denominator, as the case may be. But I heard from David Hoffman at Intel, there are approximately 94 state privacy laws at some point in the process of discussion and introduction. And I think that we are soon going to be facing, in the absence of a federal privacy law with preemption, an unworkable patchwork. Many times there's going to be direct conflict between state laws about what can and cannot be done. And so one wonders how that would actually work. If there are prescribed content specific buttons that need to appear on a website, does that mean you're going to have 50 different buttons on the website? Or are you going to have a pull-down menu that says, I'm in this state, and then that dictates which of the 50 company websites you get to see? So I think for that reason, given the need for predictability and certainty, we're going to need federal privacy legislation. I think a second trend that's driving that need is information asymmetry. I think consumers are very much in the dark about the way their information is collected and used. I believe consumers are rational actors. I have abandoned the notion of control, thanks in part to discussions with Peter and others, but I do think that there is some role for consumers in determining which websites to use, which browsers to use, and whether to participate in social media. I, for one, am not on Facebook or Twitter. You can only find me on LinkedIn, but that's my personal preference. But I think the level of consumer confusion is significant. One of my favorite statistics is from a 2017 study that found 62% of respondents think the following statement is true, and 16% say they don't know. Quote, if a website has a privacy policy, it means the site cannot share information about you with other companies unless you give the website your permission. Now, those of us sitting in the room know that that is clearly a false statement, but the vast majority of Americans think that that's either a true statement or they're unsure. And so I think that is emblematic of the amount of consumer confusion out there. And so I think we need more transparency and more consumer education. It's one of the things that the FTC is very good at, but perhaps there are ways that legislation can assist. And then finally, I think we do have, as Peter noted, sector-specific laws that govern certain types of information. So financial information, we have Gramm-Leach-Bliley. For health information, we have HIPAA. For information obtained from children, we have COPPA. But if I wear a Fitbit that's collecting health data, that's not covered by HIPAA. So in the interest of full disclosure, I'm with the FTC. I can't say anything that's false or deceptive. I don't wear a Fitbit anymore because my dog has eaten 2 of them. And I've given up trying to have them around the house because they'll get eaten. But if I did have a Fitbit, the information that it gathers wouldn't be covered by HIPAA. So I think those are just 3 of the trends that are driving us to the need for federal legislation. And let's turn now to some of the things that I think would be helpful to see in a federal privacy law. So before I begin, there is in testimony before the Senate in November 2018, the commission, as a commission, all 5 of us agreed on the following statement. We urged Congress, quote, to consider enacting privacy legislation that would be enforced by the FTC. So as a first element of what I'd like to see in federal privacy legislation, I do think the FTC is the appropriate agency. The FTC has a great deal of experience in this area, as I described briefly, and so I think the appropriate home is at the FTC. I also think a law should provide for civil monetary penalties. I think one of the things that I've heard in talking to industry is that the fact of significant penalties embedded in the GDPR is one of the things that's driving compliance with GDPR. I think the FTC has a role to play even before thinking about applying civil penalties. I think there's a great deal of business education that will need to occur under any new federal privacy regime, but I think there is a role for civil penalties. I think a new federal privacy law should grant jurisdiction to the Federal Trade Commission over nonprofits and over common carriers. I think those are big areas where the FTC cannot be involved right now, but those entities do collect a lot of information about citizens, and so I think it's important for us to have authority there. And then I think preemption, as I noted, is very important. I think it's going to be very unworkable for industry if we don't have preemption. I was meeting yesterday with a number of different businesses, and they were describing some of the very real, significant, practical difficulties that would be experienced if they needed to labor under 50 different state laws. And so I think their stories are compelling and insightful. We need to listen to that, and I think preemption is going to be a very important element of federal privacy legislation. I also think we need to be very cognizant of the learning that we've had from GDPR so far. I think Peter mentioned, and statistics confirm, once GDPR was passed, we have seen a decrease in competition for advertising. Ads have fallen, and the advertising has become more concentrated in some of the incumbent players. We've also seen a significant decrease in venture capital following implementation of GDPR. And I think we need to be very careful crafting a federal law that promotes innovation, that allows flexibility. Privacy is important, but so is competition. And so I think we need to be very careful as we're moving forward to take into account how we can allow flexibility, room to experiment, continued innovation that is what makes America great, frankly. I don't think that GDPR intended to have those effects, but of course, every law has unintended consequences. How do we minimize those? And then finally, I think it's important to have legislation that ensures interoperability and international data flows. I think there are some interesting questions that arise in this area. For example, in the EU, the right to restrict or delete data, which is, the right to be forgotten, conflicts with our First Amendment principles. Also here in the United States, companies are free to, quote, think with data. We can use data in a variety of different ways, but there are limits on how we can act with that data. But elsewhere, including under GDPR, businesses need to give permission to companies to even think with the data, and I think that can have a chilling effect on innovation. And so how do we deal with interoperability where some of the underlying presumptions that have been built into the laws in other jurisdictions conflict with what we'd like to accomplish here? And then finally, and I touched on this, I think enactment of U.S. privacy legislation ideally would be done in conjunction with data security legislation. I do see these two issues as two sides of the same coin. If you're collecting the data, you need to have a system in place to protect it. And I know that there is some interest in the Hill. Not sure whether that will be possible, but in an ideal world, that's what I would do. So I'll end it there. Thanks.
Thank you, Commissioner. It was good to get your point of view on that. One of the things that I think is a real challenge is consumers and the education. So I'm curious to see your thoughts on how we do that. When I was talking to your staff, they brought up the economic privacy paradox, which she quoted as saying they'll give it up for a pizza. And I think that is a real problem that, people think that this information is very sacred until they think that there's an interaction that they want. And then all of a sudden they'll be like, well, sure, my password is. And they'll continue to, give you information that they just told you they didn't want to give you. So how does the Federal Trade Commission kind of work through the consumer process? How do we get people more educated about what's going on in this space with both privacy and data?
So I think, let me take the first nugget is the privacy paradox, which is to say people say that they care a great deal about privacy, and then supposedly their revealed preferences indicate that they don't. And I think, I believe that consumers are rational actors and that they are well positioned to make choices that are in their long-term best interest. And I've only been on the job 6 months. During that time, I've been attempting to crawl up the learning curve on some of the economic literature that underlies the privacy paradox. There are indications that there are some flaws in that analogy. I think information asymmetry or lack of understanding is one perhaps rationale for the privacy paradox. I think, consumers may give consent, but then they don't realize the full extent of that consent in terms of how the information will be used. And then I also think, excuse me, there's privacy resignation, right? We are, especially after GDPR, inundated with different notices and 27-page privacy policies and lots of data breaches. And so I think consumers feel to some extent that information is already out there, and they have no ability to withhold anything even if they wanted to. And so I think those two factors, information asymmetry and resignation about privacy, are what drive some of the results we see that lead people to conclude there's a privacy paradox. In terms of what the FTC can do about that, the FTC has a very robust consumer education program, not just in English, but also in Spanish. And it is one of the core missions of the FTC to educate consumers. And I think we need to just continue doing that in this area. But we do have a great deal of information on our website, and we have commissioners and staff speaking to audiences like these and consumer blogs to help get information out there about how information is collected and used. And I think we will certainly do that under a new privacy law as well.
I remember former Commissioner Orson Swindle trying to do Dewey the privacy turtle, and I thought I would never put him in charge of any of my marketing plans. So nobody understood what Dewey the privacy turtle was trying to do.
So
but it was an initial thought.
That was my first
Oh, you're going to say it's my idea, right?
No, I think it was Dan Caprio's idea. But I think one of my, is Dan here? No, good. But
he's probably watching.
One of my first questions when I arrived at the FTC was, are we still using Dewey? Is Dewey still here? And people were like, what? Who? What?
Right.
I'm like, Dewey, the turtle. And they're very confused. So, yeah, I think we've moved on.
Okay, good. I'm glad to hear that. So from the idea of the industry silos, and as you said, you just been meeting with some businesses, and how are we able to get symmetry in the transparency so consumers at least understand things from the consumer standpoint, even though they're looking at it maybe as a banking transaction or a healthcare transaction? Is there a way to kind of like smooth the path for them on the information flow?
So I hope so. I think this points out one of the conundrums that we're facing. There are lots of frameworks and lots of sets of principles about what will be good and useful in a privacy law. We all agree we want transparency, we want risk assessment, we want it to be tied to harms. But moving to legislation is very difficult. And I know people that are grappling with it. I know people that have said, we can't do it, and we hope the legislators can. And so I think that's the goal, but I think doing it in practice may be difficult. And so that's, I think, again, one of the places where the FTC can have a role to play. I think in terms of federal legislation, the FTC should be given rulemaking authority, targeted APA rulemaking authority. I think it's up to Congress to weigh the different values in terms of privacy and competition and innovation and create the broad strokes. But the FTC can be very helpful in filling out what those mechanics look like. And one of the things that the FTC did in Graham-Leach-Bliley and has done in other areas is to help design information that consumers can access and internalize in user-friendly ways. And so I think that's a place where once the legislation is drafted, the FTC could play a role.
I really applaud your point that you need to keep privacy and data rolling together, because they really, for one person's privacy is somebody else's data. And what companies understand is, should I keep it, shouldn't I keep it, how long should I keep it, when should I be exiting? I think cloud computing actually brought us the challenge of more data bloat, because you can keep all that information. Now there's also, I know you've done some work in the artificial intelligence area of, the more we can continue to bring information in, it's an iterative process. So finding the way to delineate between personally identifiable information and the data that's informing the system will be really key to that.
Yeah, and I think Peter touched on AI and the extent to which it's even possible anymore under GDPR. And one of the principles that the FTC has talked about for a long time is data minimization. And at our oversight hearing in October, one of the senators asked us, how do you balance AI and data minimization? And I think it's a great question, and one that I think we as a society are going to need to grapple with. I think there are benefits from AI. Obviously, data minimization in some contexts is still a good and laudable goal, but there's a balance that needs to be made.
I think you made a really interesting point, too, about preemption as we move into potential federal legislation that I think that would actually cause a lot more consumer confusion. I know one of the things about GDPR that bugs me the most is the import of the cookie notice onto websites, because it's just a click through. I call it the mattress pad of the internet. You just click through it, people don't read it. That's the problem with most of our terms of use, is that you know you have to click that box to get what you want, but you don't know what you just agreed to. I think if we have 50 versions of this, it would be, it would continue the nightmare.
And I think that's one of the things that the FTC has also said, that if you can have whatever notices or choices, if that's appropriate in the right context, in line with the flow of whatever process you're undertaking, that would be better. So just-in-time notices, just-in-time choices, as opposed to an endless sea of things that you need to click, or 27-page privacy policies that no one's going to read. How do we give consumers options as they need to make those decisions?
I've always wanted there to be some version of an emoji thing where you could look and there's like the 5 things you care about, and maybe you only care about 4 of the 5, and you just look for the one that might be missing. Because I know there are days I've been really aspirational and try to read those terms of use, and by page 15 I'm usually done. So you talked about predictability and certainty. How do you think that industries are feeling about this process as you've talked to them? Are we going to be able to get to a point where we can have predictability and certainty?
I certainly hope so. And it's very interesting. Yesterday, one of the most, I think, remarkable points that was made in a room full of large companies who, of all the companies in America, are best equipped to deal with the morass of 50 different state laws. They said, it's completely unworkable, and give us, pardon my French, the crappiest law on the books, and we'll deal with it. But if you give us 50 laws, it's completely unworkable. And so the need for predictability and certainty is very real. I think without that, people aren't going to invest. People are going to be worried about innovating. People are going to worry about pushing the boundaries, which frankly is one of the things that really does make America remarkable, right? We are a country of thinkers and innovators, and we don't want to chill that. Right. And so giving the predictability and certainty, the comfort to people to know it's okay to innovate, it's okay to think big and pursue. That's what makes us great, and we don't want to chill that.
That's a very good point. We're going to open up for a couple questions. Some mics back here. You go right in the back there. Start there, and then we'll move up front. Please identify yourself and any affiliation that you have. Mind standing up?
Hello? Yeah. Thank you. Marian Bax from Inside Cybersecurity. This actually popped into my head when Mr. Winn was speaking as well. But to be clear,
hey, Will.
Not asking you to comment on the consent order or anything like that as regards Facebook. But my question is, there are some observers who say the current sort of sensitive versus non-sensitive rubric for determining what kind of data should be protected would not have required Facebook to protect the kind of data that was used subsequently to inform political campaigns. So what's your thinking on how we can ensure that data that's not your social security number or these other sorts of sensitive categories of information are protected if you're not using some sort of consumer control?
So obviously I can't talk about an ongoing investigation. The FTC has announced that it does have an investigation in that area, but I'm going to stay very far away. What I can say is that the FTC long has advocated for a risk-based approach. So we look at information in terms of a sliding scale. And if it is very sensitive, including information from children, health information, financial information, greater protections should be afforded. If it is less sensitive, if the harms are somewhat lower, then businesses can adapt and provide fewer protections. So I think I'll leave it at that.
Great. The lady in the green back there. Thanks.
Sorry. Thanks. Hey there, Katie McCall of Digital Liberty, Americans for Tax Reform. Just like a couple of questions, and I'll be brief. Going off of that, like the different categories of data, I think it's really important that those get defined before we start getting to the end stage. So if you have any viewpoint on how, like I look at as private, user-controlled, and public. So if you have any ways that you look at that in particular, any kind of light that you can shed on that. And then also, I'm a little bit nervous about an agency having enforcement, rulemaking, and penalty authority. It sounds like a whole lot of power in one place. So how do we keep that from getting out of hand?
So 2 great questions, Katie. Thanks for coming out. It's good to see you. And I will say as an aside, I have sought the wisdom of a lot of people who have done way more thinking in this area than I have, including from Roslyn and Katie and Peter and others in the room. So thank you, Katie, for your thoughts. In terms of the ways that we can categorize information, I think there are lots of different taxonomies out there. One that I've been thinking about recently is the origin of the data. Is it provided? Is it derived? Is it inferred? And perhaps the protections that we afford to the categories are different. Obviously, there are lots of other taxonomies as well. But I think, again, we do need to take into account a risk-based approach. In terms of rulemaking authority and a lot of power resting in one agency, I agree with you, right? And the FTC has been very cognizant of this. In the 1970s, the FTC went on a rulemaking spree and was labeled the national nanny. And because of that, Congress imposed not APA rulemaking, but MAG-MOS rulemaking, which requires a lot more checks and balances and information gathering. It's a much more laborious process. And so when I say I'd like to see narrow, targeted APA rulemaking, it is with the history of the FTC in mind. I think the FTC in recent decades has demonstrated that it is trustworthy in terms of the power that it has and the judiciousness, if that's a word, with respect to which it exercises that power. But I hear you, and I do think it is for Congress to weigh and balance the different values that our society cares about in this area and to allow the FTC rulemaking authority to flesh out some of the mechanics. But I think it is important for Congress to carry its load at the beginning of the process. And frankly, what I've heard, and I'm not sure to what extent it's true, when we've tried to do data security legislation previously, those efforts have foundered on how to define PII. And it's one of the reasons that people think if we can get privacy legislation done, data security legislation can follow. And I hope that's true, but it's a thorny issue, and I think it's one that hopefully Congress can provide guidance on.
So we have a question right up here in front. Microphone. Yeah, yes, just for the recording. Thank you.
Thank you. Stuart Gerson, Epstein, Becker, and Green. I was once Pete Winn's boss and his adversary on a number of occasions as well.
You're just here to haze him?
I'm sorry?
Are you just here to haze him?
Well,
yeah.
We'll see about that.
Okay.
Taking his, I think, very useful metaphor of creating a self-actuating ecosystem of trust, you don't mention the critical infrastructure, you don't mention national security, you don't mention incentives to be provided in some system, and you suggest that you need rulemaking authority. Why, given the fact that heavier enforcement has not reduced the number of breaches, both within and without the government, and a reticence on the private sector to engage in significant threat vector sharing, at least to the extent that the government thinks is important, and with private industry having heavily involved itself in NIST processes, why would it want to turn to an agency that views itself primarily as an enforcement agency to maintain the ecosystem that Pete describes?
So I think it's a great question, and as an aside, I wouldn't want to be Peter's adversary. I think I'd lose out in that matchup. So the Federal Trade Commission obviously has a large role to play in terms of consumer protection. We are not dealing with issues of national security. I don't think the FTC can answer all of the questions. But in terms of the ways that privacy and data security legislation will impact consumers, the FTC is the right home for that. But obviously, there are many other agencies that are far better equipped to deal with national security and infrastructure than the FTC.
And then we had one more question for Peter, the European Commission.
Thank you. My name is Peter Vertelning. I'm working for the European Union delegation here, and my standard phrase is always, thank you for the advertisement for the GDPR you're doing. So there's no way I could reach that audience without you. Now, my question is, it's perhaps, we're in April, so there is perhaps a chance that CCPA will enter into force. I don't want to speculate, but it may be one of the options. The future will play out. How do you see this will alter the conversation we are having, like if we were to be in a year from now?
So it's a great question, and I think largely it's a matter for the Hill. Frankly, I think, from what I've heard, it is one of the driving forces in terms of the timing of privacy legislation. I think people would like to get legislation passed before CCPA comes into force.
We have time for one more question. We've answered them all? Well done.
Oh, I highly doubt that's the case.
I know. I think we've scared them. I don't know what happened. Great. Well, Commissioners, thank you so much for your time and all your effort in this area. We really appreciate it.
Thank you.
Now. Yeah, thank you. Thank you.
Peter, I'll let you go last, no matter where your name tag is. All right. Thank you guys for hanging with us there for a second. All right, this is a great panel, and I'm going to highly encourage that if you're not familiar with the people that are on the stage right now, that you go visit their websites and see some of the great work they have been doing. I'm going to just do some real quick introductions. Pam Dixon is the founder and the executive director of the World Privacy Forum, and she has done some fantastic studies on third-party data sharing and artificial intelligence, which I hope will really guide some of the work that we see doing not only here in Washington but globally. So I'm very excited to hear from Pam. Joe Jerome is from the Center for Democracy and Technology. He has been focusing on legal and ethical questions on smart technology, artificial intelligence, privacy networks, and promoting privacy for quite some time, as well as Internet of Things. They have a discussion draft legislation, which has made him highly popular here in Washington, so we're very lucky that we can have him here today. My colleague, Brett Swanson, is also a visiting fellow at the American Enterprise Institute, where he focuses on technology and the U.S. economy, telecommunications, and internet regulation. He's also currently president of Entropy Economics and a scholar at the U.S. Chamber Foundation. And Peter Swire is a professor of law and ethics at Georgia Tech Scheller, am I saying that right? College of Business, and he's also an associate director of policy of the Georgia Tech Institute for Information and Security Privacy. And Peter's done an incredible body of work and has recently had a two-part paper that he's done with the a privacy foundation, which is very easily searchable, and I read it last week and learned more from it, and I look forward to learning more today. So we are going to actually start with Pam. Just give us a couple minutes. We'll go down the line, and then we're going to get into a dialogue.
Well, thank you so much, and thank you for your kind introduction. That was very nice of you. And it's a pleasure to be here. I love being around people who have a lot of ideas, and all of you do, so I'm delighted to be here and talk with you. So I definitely have a few ideas. I've been doing privacy for about 25 years. I started doing it long before it was sexy, and the thing that compelled me about it was the data. I am absolutely a geek. I don't even apologize for it anymore, and I really enjoy looking at what's happening on the ground with the data, and I like to observe what it's saying to me, and then really think about architectures of how the data moves. So I'm kind of the opposite of rhetoric, and when I end up saying something, it's because I've looked at the data. So I've been looking at what to do with privacy data ecosystems. So I want to move to like an example so it will make more sense to everyone. So one of the very first things I started looking at was medical identity theft way back when. And what I discovered was that this was a crime that was happening and absolutely no one had talked about it or known about it. And so I unambiguously documented the data, and it took about 8 years until we got medical data breach notifications, but we got those, and then a lot of other corrections came, and a whole lot of folks in the healthcare sector began to organize themselves to make rules around how to solve the medical identity theft problem. So let me ask you a question. Did medical data breach solve a problem? The answer is yes. So that was command and control regulation. It was very surgical strike. If something happens to someone's data, you're going to let them know about it. That's fine. But could command and control regulation have solved the deeper problems that every healthcare provider was having with this problem? The answer is no. It wasn't possible. And the reason why is because healthcare data flows are extraordinarily complex. And you cannot look at a 500-bed hospital and say, oh, we're going to devise rules for you that also apply to this one-person family physician office in a rural area. It doesn't happen like that. So what we used in that process was actually much more of a multi-stakeholder process where people got together and said, okay, here's what worked for us, here's what didn't, et cetera, and people devised their own rules. So that was very influential in my thinking for many years. So what I've been doing recently in thinking about privacy and data ecosystems and what on earth we do, I've just come out of a 2-year OECD process where we just completed and got approval on the global guidelines on AI. They'll be the first soft law guidelines that come out, and they'll be coming out around G20. But here's the thing that I learned about the guidelines. The guidelines are very broad, and it's going to be up to the individual stakeholders to figure out the rules. And by individual stakeholders, I mean very small slices of the data ecosystem. With AI in particular, you don't get to say, here, healthcare sector, here, financial sector, here's how you need to use AI and control your data flows. It's got to be a lot smaller than that. So in looking for something that would address complex data ecosystems, I completely stumbled across the work of Elinor Ostrom. And I've been very, very excited about it. And I've been working for about 1.5 years to figure out how to apply Ostrom methodologies to complex data ecosystems. So very briefly, so I won't hog any more time. Sorry, this is hard to explain, and I've learned I have to say more, not less. Okay, so in looking at my work today, so let me give you one example where command and control still works. Actually, I already gave it to you. Let's keep with that. I think, there are some instances where you have to have a command and control. How about a better one? You need to post a privacy policy. We can definitely tell people to do that. We can agree that that's a good thing to do. We should all have those things. Data property rights. Yeah, that's really tough in privacy. Let me tell you when it works, though. We work with a lot of people who are victims of what I would call extreme domestic violence situations. And in those situations, we hand them off to people who help them change their identities. They work with the Social Security Administration. They change their Social Security numbers, and then that data is sealed. That data belongs to them, and it works. That works, but it doesn't work for everything. That brings us to the Ostrom principles. Ostrom had 8 principles of how you manage extraordinarily complex data ecosystems. And this gets us to something very important to me. So Joseph Jerome will know this. I have written scathing reports on self-regulation. I mean, it would burn your hair off to the roots. And the reason why is because they haven't worked. Industry tends to get in a corner and talk to itself. And then you have other stakeholders, like privacy groups, that go off in the other corner, and then they talk to themselves. And the result is something like California, where only one person talked to himself and then made a law. So I think we have ample proof that that doesn't work. But the opposite thing does work. Can we possibly conceive of a way to provide flexibility that would allow for something between COPPA and the Privacy Act, where there are bubbles of allowable data use, and people, the stakeholders involved in those bubbles, get to talk about it, and in a consensus, not majority, true consensus fashion, figure out those roles, and all the stakeholders are involved. Wouldn't that be great? There's a methodology for doing it. It already exists. We don't have to make this, but we do have to figure out how to apply it to privacy, and that's what I'm working on. So those are my comments. I'm really looking forward to all questions. Oh, and someone asked about the FTC role. I really like the idea of Magnus and Moss lifting. I also really like the idea of reverse forbearance. So, love to talk more about that.
Thanks, Pam. Joe?
Thank you for handling the self-regulation discussion. And thank you for inviting me to this. It's really an honor and a privilege for me to share the stage with such great luminaries. So you mentioned you've been doing privacy work for 25 years, and I wanted to sort of segue to say my organization, CDT, has been advocating for a federal privacy law for 25 years. So we've been asking for this for a long time, and it really seems like now there is some momentum. And so I wanted to sort of start with Commissioner Wilson. You sort of mentioned that we're sort of awash in frameworks right now, in principles documents. And the reality is, it's time to start putting pen to paper. So I'm waving the CDT folder that has our discussion draft on it, and we spent 9 months trying to write a privacy discussion draft. There's a lot in it that we're incredibly proud of, and we think are good ideas that people can take and use as appropriate. There's also stuff we probably got wrong or could use further discussion. But we did actually start writing stuff. And we are well past time. People just keep putting out these frameworks. And I know that there are a couple organizations that have worked at little bits and pieces, things like legislation around data portability or defining personal information. But by and large, if you don't want to do the whole thing, at least get invested in certain specific parts. And that isn't what anyone is doing so far. I mean, we have to give a lot of credit to Intel for putting out a discussion draft because there just isn't anything else out there right now. And as you're talking to hill makers, they don't want lofty principles about more transparency or accountability and risk. They want to know how you're going to write that and then what you're going to maybe punt to the Federal Trade Commission. So my ask for all of you is, go to cdt.org, take a look at our discussion draft. If you like stuff in it, that's great. If there's stuff in it you don't like, do a better job, and then go talk about that to folks on the Hill. To sort of get off of the discussion draft point, one thing I thought was really interesting about both Mr. Winn and Commissioner Wilson's presentation were the notion of this lack of trust and information asymmetries. And I guess I'm sort of here with the message as the privacy advocate in the room that I think that's exactly the problem. And I also think, like, how do we expect people to know any better? I look over the last 6 months, so this isn't just the long litany of 25 years of privacy problems. This is the last 6 months, and we've seen headlines, stories, exposés about improper selling and sharing of location data, really, frankly, cavalier attitudes by companies about the deployment of biometrics and facial recognition technologies. And we've already sort of hit on, like, nobody knows what's going on with health information, if we can even appropriately define health information. And then, there are things like just last week, data brokers saying that they do not sell information about children, and then it's revealed that they are selling mailing lists about children. That's probably a deceptive issue, but it just goes to say that the string of privacy problems is growing and endless, and highlight and emphasizing areas of data that I think we all agree are sensitive or warrant special consideration. And so my ask is, if we're talking about information asymmetries and lack of trust, I don't know if more transparency, more privacy policies is going to solve the day here. When we're talking about really cavalier attitudes about data, I think we need to have guardrails in place, and we need to start making tough decisions about things we aren't going to do, profit-making opportunities companies aren't going to avail themselves of, and that's what I think is meaningful privacy regulation in the United States.
Great. Yeah, microphone stays with me. There you go. Brett. Go ahead, Brett.
Great. Thank you. First of all, just let me again compliment our two first speakers who I thought offered really very, very thoughtful comments. I learned a lot. I have four hopefully quick points. One, I want to talk about the information gap. Two, incentives and innovation. Three, enforcement. And fourth point that just brought up because of Peter's comments are about something I call the mismatch. First, a lot of my work the last couple of years has been focusing on productivity in the economy. And the root of it is that the 30% of the economy that we call the digital economy is growing very fast, lots of innovation, very high productivity growth, and then along with that comes high income and wage growth. But there's 70% of the economy, sort of everything else, where the productivity slowdown has been focused. And the interesting thing is that 70% of the economy doesn't have nearly the information intensity of the fast-growing 30% of the economy. So if we want to make transportation and healthcare and education and manufacturing and logistics and retail, all these other industries more productive and have higher wage and income growth, they need higher information intensity. We need to be using more data in all these industries. And so whatever new framework law regulations we devise, we want to make sure that we don't have disincentives for all these other industries to use more and more information and data. The second point about incentives is I think we shouldn't underestimate the natural incentives that firms have to increasingly emphasize privacy as part of the value proposition. So if you just look in the last couple months, you have a bunch of different examples. It's possible they were slow on the draw, but in the last couple months you've seen Apple unveil a huge ad campaign, which they call Privacy Matters. You've seen Facebook, which obviously has had its issues, but they've potentially changing their whole business model to focus on encrypted private communications. You've seen a huge venture capital funding, private equity funding going into security and privacy startups. I've got a bunch of examples on that front. And so, yes, maybe it's taken us too long. Maybe we're just catching up. But we shouldn't underestimate that over the next couple of years, we're going to be making a lot of progress reacting to people's natural incentives and to consumer wants. One brief point on enforcement is that there's just no way that we can write into law and regulation all the possible definitions and scenarios that can come up today, let alone which will come up 2 years from now or 10 years from now. And so that's why I think the FTC's basic framework that they use, costs and benefits, consumer harm, is actually the right way to go, with some new bolstering the current framework with some updating it for the 21st century. There's another reason why I think it's useful, is because we can't think of all the things that might go wrong, all the possible harms, all the definitions. If we give too much of a detailed law and regulation, we may actually have possibilities of under-enforcement, right? Where people are actually complying with the letter of the law, but we're not actually helping people that have actually been harmed by something that we couldn't foresee years from now. The last point, and it goes to Peter Winn's great comments. As the father of 3 teenage daughters, I loved his playground analogy and blabbermouth paradigm. My latest article is actually about this mismatch between hyperscale information networks and hyper-diverse social networks. And I think that the human behaviors that we have developed over millennia, developed on the playground, we simply weren't ready for the explosion of information networks and putting our social lives on this. And I think that's created a lot of the issues on whether it's social networks, social media, or privacy. And I think we need to, we're just starting to understand these right now. I think we will be developing the new version of the playground paradigm for the 21st century over the next couple of years. But this is a sort of a natural human evolutionary process that we're going to be going through.
Thanks, Peter.
Hi, everyone. It's a delight to be here. I followed the work of Robert Hahn and other AEI folks over the years in this area and appreciate being here today. I'm going to give a very short background piece, talk about why preemption matters, and then propose one innovative way to work with preemption that might be building on what Peter Winn and Pam Dixon have said. So there's a research project I've worked on called Markets, Self-Regulation, and Legal Enforcement in the Protection of Personal Information. And I published that in 1997. So these, we've been here before. Microsoft had a big advertising campaign on privacy in the mid-2000s. It was trying to beat Google. It went away when they found out they couldn't beat Google, and they stopped spending on it. So in some ways, for those of us who've been in this debate for a long time, it does seem like what's old is new again. But there's something different this time. What's different this time is that other people are passing laws other than Congress. So there's not just GDPR, but Graham Greenleaf shows 120 countries in the world that have broad-spectrum privacy laws. That's the norm, and they're copying Europe. They're not copying the United States. But more important to the United States and to Washington, D.C. discussions, California happened. And Washington State will probably happen, and Massachusetts might happen this year. And everything changed when California passed its law. The reason is companies will have compliance issues with the California law in January, unless it somehow gets stopped, which I don't think it will. And so now the choice becomes, is California going to regulate, or is Congress going to regulate? And so the AEI approach of permissionless innovation has basically won in the Congress for the last 20 years. But it's not going to be able to win, I don't think, in the same way going forward. And that's why we're in a new stage. That's why people like the Chamber of Commerce are talking about privacy legislation, which is not their usual, let's have more regulation approach to things. So we're facing this legislation, and the preemption is absolutely central to this. The carrot for industry is have a federal law, and then all the states are not going to make it impossible for us to do business. But in preemption, generally, you can't beat something with nothing. You can't preempt and say there will be no privacy protections. You could legally. There's ways you could try to do it. But it's very hard to go to Congress and explain why we're taking away all these privacy protections that people have. So I don't think that's going to be a viable thing to do. And preemption is super difficult. The things I wrote gave 15 reasons why it's hard to write a preemption provision. You can go read it on the International Association of Privacy Professionals page.
So here's one path for a preemption that I haven't talked about previously, I've talked privately with some folks about before, that might actually solve some of these problems. And it goes something like this. You could have sectoral codes, self-regulatory efforts, advertising efforts, location services efforts, student privacy efforts, and then they get a seal of approval from the Federal Trade Commission. And if they do that, then they are the national standard and they get preemption effect. Now, this might sound crazy, except it's basically what we have under COPPA, the Children's Online Privacy Protection Act. It's basically what we had under something called Safe Harbor, which we negotiated back in 2000 with Europe. And so the idea of basically referring to private sector efforts so that you get sectoral expertise, but it has the rule of law once a government agency has said, yeah, you qualify. It's not perfect. Government's still involved. It's not permissionless. But it has a way for sectoral knowledge to come in. And with procedures around it, it has a way for privacy experts and other stakeholders to come in. I think that's part of what Pam might be studying right now, which is typical because Pam's usually about 5 years ahead of everyone else in this field. I mean, talking about medical identity theft 10 or 15 years ago was visionary for Pam. And this is now where the action is going to be. Because if you pass one big federal law with just one set of words, which is what GDPR has, it's very hard to change it, hard to revisit legislation. People are going to be worried about unlimited FTC rulemaking power. And then how do you ever update? Right. And one way you update is you get smart people in industry who are living it, who have to confront the other stakeholders, which is the democratic process Peter Winn said. Then you have a chance for industry knowledge to interface with the public concerns, and you have a chance to update it over time. Right. So that's a way to at least solve a bunch of preemption, because where there's good safeguards, these federal national standards happen. Where there aren't, it's going to be hard to take it away from California and the rest. So there's an idea to consider.
So, Peter, do you see this as a dynamic process? I mean, you're
talking about a dynamic?
Yeah. I mean, how do we manage through? We had these laws that came on, a lot thanks to CDT and Jerry Berman. Thinking about things, and children, people could coalesce around. But now we have these different, versions of it, and that part of the work that you've done, I think, is really interesting. Is we have these standards, but how do we continue to update them and keep them relevant in a very technology-based world?
Well, one way to update them is to put sunsets on them, right? So you have a 5-year deal.
I believe that.
And then industry, unless they can come up with a new approach that gets approval after 5 years, loses its goodies. And that's been a way to unless we've seen with the Patriot Act and other kinds of things, if you have sunsets, Congress pays attention. If you don't have sunsets, it drifts along forever. So I would probably think sunsets in order to get the goodies and force people to the table. The history of self-regulation is they work in two periods. I've testified in Congress on self-regulation. They work when industry is scared temporarily. And industry works like crazy the year before Congress might act, and that's when we get self-regulation. There's a ton of self-regulation in the late 90s when people thought Congress might pass the law. Second time self-regulation has worked is when you get something for having a self-regulatory code, like in COPPA. Other than that, there's very few successful examples of self-regulation and privacy that actually has teeth.
Can
I follow up?
Yeah, absolutely.
I really agree with that completely. And the idea of self-regulation is great because it's flexible, right? But you cannot run into a corner and talk amongst yourselves. It doesn't work for any stakeholder. The key really is, and I really like Peter's idea, and it is what we're working on right now. The key really is to figure out, okay, what are the slices that you need to make? Definitely sectoral, no question. I do think that we need to think and pay particular attention to AI issues. AI issues are enormously complex, and they cross so many different jurisdictions and stakeholders and whatnot. And it's true, you have to be able to use data. I'll get to my example in a minute, but I really like the idea of having those bubbles of appropriate use that stakeholders decide. There have to be rules so that the stakeholder process is just. It allows all stakeholders to have a say, and then the FTC can go, yes, you conducted this process correctly. All the stakeholders had a say. It's consensus. Great. And in regards to the sunset, I think that's a great idea. because these processes have to be iterative, especially with the new technology. Your comments about the 30% of the sectors, I'm going to have to talk with you more about that. It's very compelling and very interesting. We have to increase that. We've got to make that number. We've got to invert that number, right? That's the goal. And we have to have information to do that. But we don't want informational harms. And this is a way to figure out, okay, where are the harms? Here from the bottom up, not from ideas and theories that aren't necessarily true. So I was in Dubai in just I think it was about 5 weeks ago, and I went there for our very final OECD meeting to help finalize the AI principles, second to the last meeting. And the World Government Summit was occurring at the same time. And I went and I attended, and I was utterly stunned by something, which is, you know, Dubai is a Belt and Road Initiative country. And as such, it had a lot of meetings with China and with other Belt and Road Initiative countries. You may have something to say about this. And I was utterly struck by the sense of all of these jurisdictions lined up at a starting line, utterly focused on winning, a goal of winning the AI race. And let me tell you, if we cannot compete at that starting line, we are in trouble. So I'm very interested in how to make all of us on that starting line and win. Yes, we want to win. How do we do that in a way that gives everyone a seat at the table, right? Companies get a seat at the table. They're making the products, right? End users, people like us who are impacted by these products, by these decisions, we get a seat at the table. I don't want a world in which we have a checkbox and that's our control over data. That is not exciting to me. I want a seat at the table. Let us start to help make those decisions.
Yeah, can I just sort of jump in, because I think this is interesting, and I certainly don't think CDT is a strong believer in self-regulation, and Peter, I obviously defer to your experience in this area, but I mean, you know, it's interesting. Do people on the panel see COPPA as like a big success? I mean, there's plenty of people out there who have large systemic problems with COPPA. Senator Markey has issues with COPPA, but then my larger overall question is, I'm just sort of curious how the type of framework you envision, does it do anything more than sort of provide notices and opt-in, opt-outs? Like,
you devise the rules. It's not self-regulation. The Ostrom has a completely different theory than self-regulation. It's really a matter of cooperative governance. It's a very intriguing and actually quite well-studied theory now. She spent 40 years documenting. That's why she won her Nobel.
But it's, how does it become equitable? Like, you want a seat at the table. So that's, I just, you know.
There's rules.
Okay. So how you divvy up the seats,
I think we give Commissioner Wilson and the FTC a role in watching the negotiations of a standard.
Okay.
And if the standard comes up, there's some set of criteria against which you measure the standard, including was there process, notice and comment kinds of things.
Right.
And then if it meets some somewhat vague statutory standard, is this reasonable protections or whatever, the FTC, based on its hearings and its expertise in the public record, says this one doesn't work or this one does work. And if it works, then you get goodies. And if it doesn't work, you don't. All of the approaches have flaws. Self-regulation on its own has been proven to lead to weak protections for a quarter century. Command and control in Europe has a long list we don't like. And then somehow trying to find procedures where there's incentives to update and have pretty good protections and have pretty good innovation, somehow that's the sweet spot people are looking to. And out of our limited set of choices, this is one where at least you have a chance to get updating over time.
So one of the big problems of our era that we have to solve is the data broker problem. So I've spent 25 years researching data brokers. If you need to know anything about data brokers, please come talk to me. I can talk to you about it. It's very hard-won information. There's a report we wrote called The Scoring of America. We wrote it in 2014?
Yep.
Yeah, it was 2014. It took us 7 years to research that paper. It was hard. No one wanted to talk to us. So
but
we
data
had to go to
brokers
their
provide transparency.
Oh,
they've said that.
Hang on. The data broker problem is a classic hard problem, which is why I've stuck at it. And we need to figure out how we can set parameters. Some data brokers at least attempting to follow some kind of ethical rules, but many others aren't following any rules at all. So this is a sector that would really benefit from a process. I cannot think of a single regulation that would work for data brokers other than something very minimal. And the reason why is because they all have different structures. There's about 50 different business models that data brokers will tell you about. So you can't have a one-size-fits-all approach, but we have to start solving these problems. We can't just let completely unaddressed data use continue because there are real harms. I just got an email yesterday from a consumer saying that he had been on the phone with his bank for 45 minutes, and he was asking if it was due to a consumer lifetime value score. And the answer probably is yes. And he's like, what can we do about it? And it's like, well, that's what we're talking about, right? It's tough, though.
To bring this into a more recent study, Fordham Law came out this winter with a piece called API and Your Privacy, and it was about apps and third-party data sharing, which is another part of the data broker situation. And as we know, a lot of the apps work in the background. They need information. They need GPS information to give me, like, particularly like weather or Waze, or if but there's the question is the handoff, and that's what I think a lot of consumers are very confused by, myself included some days, of when I'm clicking on that terms of use for a specific app versus when does the information get sucked through the straw to make other things happen. There's almost a interesting elegance to the way the Chinese just say, we're doing it all in one place, and we're trying to do it in a truncated fashion. So how do we, I feel like we've got a conflict here between needing more, not less data to, Brett's has mentioned this before, because we need that for especially AI, dealing with transparency, but then also making sure that the technology has the ability to function and not truncating it because it gets caught into a legal situation where we've said no, but we need that data to be shared. Thoughts?
Yeah. Well, I think it's a great point, and I think that's why, because we have basically endless variety of different combinations, right, in the digital world where everything can fit together in different ways. And so we need a way to communicate to consumers sort of what level of privacy, what they're actually dealing with, because as we all know, they can't read hundreds of copies of different terms of service, right? So we need a way to compress that information as best we can for consumers so they can make good choices. Even then, it's going to be complicated. And that's why I think the sort of flexible approach at the FTC is then needed, is because in, say, the majority, most, maybe, of these situations, this is going to be useful for consumers and useful for the economy, but we need a way to make sure that the consumer is at the center of the equation.
So I guess I just want to say, obviously, when it comes to the internet and digital technologies, it's a really interconnected space, and nobody wants to shut down the ability of anyone to be able to use SDKs and other third-party sorts of code to build and augment applications, platforms, and services. But I think part of the confusion here is companies for a long time have played really fast and loose with what's the difference between a service provider and a marketing partner and an affiliate, and frankly, law enforcement. We've been doing some work with data standards that involve data sharing with cities. How is that ever communicated to a consumer in a way that makes any sense? And I go back. I didn't want to mention Facebook, but in the New York Times story, I was discussing how Facebook had creative interpretations of service provider to extend to deals with other companies. That's clever lawyering, and it's probably accurate, but it doesn't really, I think it sort of is disingenuous to how people are trying to understand the world that we live in. And I understand it's really tough to legislatively thread this needle, but I think part of the problem is really that for a long time, companies just played fast and loose about the data partnerships that they're talking about.
So is that part of the transparency that we need as consumers?
This is where, to pitch our proposal, I think we need to think about transparency in many multiple layered ways. The notion that the GDPR has where you're going to provide clear and informed information, that's impossible to do. You can't be really simple and clear and click a button with an immediate pop-up and provide everything you got to know. Our proposal is sort of bifurcated where you would rely on some elements of just-in-time notices, iconography. People now know what a location symbol is on a phone, for example. But what we really need is actually, frankly, more detailed disclosures that aren't privacy policies. We've sort of described it as akin to like an SEC type of disclosure. But that's really what I think certainly consumer groups and civil society want. If companies say they're using anonymous or de-identified data, I don't want that in a single sentence written by a lawyer. I want to know what you're talking about.
So I think that there's a very important role for data mapping going forward. It's just not possible for anyone to read a privacy policy and to have a good idea of what the data flows and maps. And ecosystems, remember, we're not talking about, someone wants, one piece of our data anymore. We're talking about, very sticky data and pieces of information that go to multiple data ecosystems. We need some maps. I'd love to see data maps that are public as much as is possible. This would have to be highly negotiated, but I really like that idea. And, if we saw the data maps, I wonder what would happen. I wonder if Cambridge Analytica would have showed up on a data map. But we need to make sure that it would have, right? So that's part of the conversation that we need to have.
So we're going to open up for questions. Anybody want to start? We've answered again. We've done a great job. If not, we will keep talking up here. Did everybody get the homework assignment to read Elinor Ostrom before this event? We'll have a reading group.
One comment on Ostrom is there's a question of how well some of that scales. Yeah. Right? So if you have 100 people and you have informal knowledge and blabbermouth kind of things, you can handle it for 50, 100, 200 people. 330 million, not as well, not without a lot of mediation.
Agreed.
And most of her examples are small to medium size. And one of the challenges for the United States compared to the Netherlands, where I've done some work, is in the Netherlands, when they have an industry meeting, everybody comes to Amsterdam in the morning on the train, and the whole country's bankers are there, and then they go home at night. And we've got 3,000 miles away. You can't get everybody in a room in the United States. And so the processes that sometimes can work in the smaller place, we cannot count on those working at scale.
So is there a possibility to change the value proposition? Because I feel like we got inverted in this early. We started giving away our data for pizza or Starbucks, or we just weren't thinking about it, and it got kind of beyond us. Is there a way to invert that?
Yeah, I think so.
Does Elinor Ostrom talk about that?
I think so. Everyone's right. Peter's right. Ostrom does not scale well. So and that's why I really think that if you look at how it's effective is in very focused ecosystems. We're going to have to figure out what the ecosystems look like. Certainly sectoral, but I think even within sectors and within other disciplines. And I do think that we're going to have a really robust conversation. Of course, I want to see some data brokers in there. But then we ask, okay, well, what kind of data brokers? Are we doing the list brokers? Are we doing the folks who are doing analytics? What are we doing? So I think some of this becomes apparent after we get some broad rules in place, but this is part of the work right now is to figure out these exact questions.
Good question over here right in front of the camera.
Hi, my name is Arthur Ferb, an attorney with Poblet Tamargo, and so one of the questions that I have is, as we are following with the whole federal data privacy issue, is the issue of preemption. Do you believe that there may be a possibility that there could be concurrent jurisdiction in handling data privacy issues?
Well, there would be for enforcement under most of the approaches. So the state attorneys general and the FTC in many of the approaches would both be able to enforce. Now, writing the standards in both places, when they conflict, then you have to have some way to deconflict them. And typically, the preemption idea is the federal law wins over weaker state laws, or maybe over any state laws. But you can have enforcement that's concurrent.
Anyone else on that?
I would just add also, everyone needs to read Professor Swire's article in the IP. No, it
is really good.
I'd like to highlight for everyone, the preemption debate, while it is definitely critical, it's been unfortunate that becomes the first thing everyone asks. It's the first question every privacy conversation. What about preemption? And from my perspective, it should be the last. We should figure out what the rules are and then do what Professor Swire says, which is talk to stakeholders that are far outside of privacy advocates and tech companies and build a legislative record, and that's how you do preemption. And I think that hard work is something that people just don't want to do on all sides, unfortunately.
There's hundreds of state privacy laws. There's dozens of categories of state privacy laws. A lot of the initial laws would preempt privacy protective laws. One example is we have wiretap laws. And in some states, there's two-party consent, right? One-party consent is the federal law. Some states say we're going to be more careful, and you have to get both people's permission to before you can record the conversation. Under language I've seen, what was supposed to be an FTC act would have preempted the wiretap rules in a bunch of states. And I don't think anyone until I wrote it had sort of pointed to that publicly. And states have laws about publishing Social Security numbers. And under some of the things, those protections of Social Security numbers would have disappeared because they protect privacy. So there's just tons of different texture in the state laws. And building the record, having staffers go, having Congressional Research Service go, rebuilding Office of Technology Assessment so they can go do it. Somehow having informed discussions of this, it seems to me a precondition of having a sensible law, and people haven't wanted to take on that homework assignment.
Then there's also state data security laws. I mean, maybe this is the avenue by which we get to actually doing data security. The conversation about preemption would probably preempt some of those. I mean, there are regulations in New York. There's the Massachusetts data security regulation is certainly when I was advising clients something that was, it doesn't matter where you were in the country, do what Massachusetts said. That seems like that's actually sort of a secret or shadow part of the debate that we're not having.
Doesn't that lead to more consumer confusion, especially when you're using a technology entity? Because, I mean, you guys see it if you travel internationally, but like, if I'm going from Arkansas to Alabama or wherever, and all of a sudden my phone's going to act differently.
I understand the premise of your question. I think consumers are already confused. Like this notion that they're going to be confused about the protections in some states, like they already don't know what they're getting from these companies.
But so we're going to add to the confusion? Is that,
this is always something that comes up as consumer education. When it's going to bring me right back to this point. It is so when we were in a paper-based world, we had different choices to make. I went to India to study the Aadhaar. Do any of you know what the Aadhaar is? Okay. So the Aadhaar is a 1 billion person strong national identity ecosystem in India. It uses biometrics to track in real time all Indian residents and citizens. I went in 2010 to begin to research the system because no one was there and no one was looking at it. It was really important. And there was enormous confusion about this. And I used to go into the offices where this system was being put in place. And I have pictures where there was a room much larger than this, and I kid you not, it was literally stacked up with paper as high as you could see. And it looked like one of those hoarders, like episodes where you'd had to like wind through the paper. And India was moving from a paper-based society to a digital society. The paper, there was privacy by obscurity. Who could get to that paper, right? No one could. Really, probably no one. But in a digital society, as soon as all that data got digitized, all of a sudden Indians started absolutely screaming and saying, hey, I think we're going to go to the Indian Supreme Court and get these rules changed because this is not great. We're getting tracked in real time. You're having an impact on whether we can even work or live or breathe, So we need rules that match a digital society. And I think when we have those, consumer confusion will begin to ease. Until then, I think it's going to be a bit confusing, but I do think as we're going through this very chaotic transition time from one set of legacy rules to something a little newer, I actually think it's very exciting, and it's a good time to try to get it right. I'm less worried about the confusion.
Great. Roslyn's got a question up here up front.
So I want to thank the panel for so many thoughtful, insightful comments, and also our speakers who have given us many ideas to chew on. Would any of you, comment on litigation? And I see it kind of going both ways. On the one hand, we have states talking about private right of action and wanting to strengthen this ability that if you don't honor whatever terms, lots of lawsuits. This is a big part of the GDPR, and I would argue that there are rights to compensation, judicial remedy, and 7 hours after the GDPR was put in place, there was $8 billion of complaints filed seeking damages from 3 American companies. So on the other hand, we may have litigation from enterprise who may interpret the legislations adopted as curtailing their speech or curtailing their opportunities for business model when, let's say we don't like, maybe we're not fans of data brokers, but they are existing, they do serve, they have legitimate customers. And if we sort of pick out and say, well, we don't like this business model, it doesn't exist anymore, how then, that group may fight back and fight the rules. So could you talk about this litigation question, private right of action, and then sort of freedom of enterprise?
So I'll respond to this in a slightly different way. So I like your idea that companies may fight back and then consumers may fight back. This should encourage all of us with the most giant hammer that exists to get it right and to make sure that we've encompassed all stakeholders. Data brokers are stakeholders too, and they get a seat at the table. That's the whole point. We all get a seat.
Can I pay a law professor answer to that on 3 constitutional arguments that we're going to hear more of? One of them is free speech. There's a case called Sorrell that can be read to make privacy legislation a violation of free speech. Companies have a free speech right to publish everything about our private lives. I hope that's not what the interpretation of later cases will be, but there's a case, a fair reading of Sorrell is most privacy legislation is unconstitutional in the First Amendment. Yeah. Another constitutional claim that's going to happen after California goes into effect is dormant commerce clause. That is such a burden on interstate commerce when you do the risk balancing that California is impermissible. My law professor radar is that loses. That states have a police power, there's concrete reasons for the state action, it's being done at scale. My guess is that loses, but I could be wrong. The third constitutional piece here is standing to sue. So in the federal courts, after cases like Spokio and others, there's an increasingly strong barrier to plaintiffs having standing unless they can show something that looks a lot like economic harm. And it's not all been worked out, and we're going to find out. But there certainly, we could have, with a sort of pro-defendant, conservative-leaning court system, barriers to federal rights of action and privacy. One thing to notice there is states are not covered by that. So the Article 3 limits of a limited judiciary don't apply to states where the judges have full power under the state constitution. So if there's barriers to litigation on the federal side, there's at least a possibility that states could keep going forward with private rights of action. And I think in the preemption debates, people haven't really focused on the capacity to have suits at federal versus state laws. And if that standing stuff happens, that might really be where the action is, because the lawsuits will be state lawsuits.
Mm-hmm. That's fascinating. I would just add that you're already seeing, for example, the Illinois biometric law has sort of unleashed a bunch of new litigation, and there are other examples where you're seeing it actually happen, so it's not just a possibility, and of course, the more laws you have, the probably greater opportunity for it.
Last thoughts from our panelists before we close?
Can I try one? I hope I can
try.
So this is for an American Enterprise Institute audience with a commitment to permissionless innovation, markets, the ability to... I think we're in a new chapter historically, where with Europe and with California, we should expect there to be laws at the national level around privacy. And it will either be Washington State and California in the United States, or it'll be Congress. And so then the question is, if you're stuck with that third best or 10th best world, how do you take the things you believe in and try to create some process where markets, where updating to modern technology, where innovation can get built in? And I think that's a particular assignment that's different from just saying we don't want legislation, but is an assignment that I think for people from an AEI perspective is an important task for the next period of time.
Well said.
I have one last thought. About 20 years ago, I came to the realization that if I wanted to do privacy, I had to get past the word no. I couldn't just say no to everything. And that was a very hard lesson to learn, but I learned it. And I would say, just echoing Peter's comments, we have to stop saying no. We have to say, okay, let's figure this out. how do we do this?
So much more succinct and better said.
I guess if we're ending with a comment for the AEI audience, I would simply sort of throw out there a cautionary tale about the word innovation. We throw that word around all the time to mean a whole lot of different things, and I think one of my mentors said it best at a conference of just privacy advocates last week, that he's been telling companies to just don't lead with that, because oftentimes, or too frequently, innovation is used as an excuse to say we can trample or ignore certain people's rights or interests so long as there's some greater perceived public benefit or commercial benefit. And as a privacy advocate, as someone who's very interested in what my digital well-being will look like for the rest of my life, I think we all have interests in our data online, and innovation can't automatically trump those things. So just a cautionary tale to everyone in the room.
Brett, you get the last word.
Well, it's just been, I think, a great discussion, great event all around. And I would just finish by saying that innovation, obviously, I focus more on that side of the equation. We've had this, right. Joe and I talked at the University of Chicago about 6 weeks ago. We had a great conversation there. I would also say that that's why I came around to saying I think we probably do need an updated law, is because consumer trust, their trust in their digital lives, right, is a key component of any system of commerce, right? And if we want our system of commerce to flourish, trust is the key component of that. And so I think that's maybe a way how we can come together on this.
Great. Please join me in thanking our panelists for this great discussion.